not so much because of the issue of legislative prayer, because that was relatively decided in the Marsh decision in the 1980s, where purely legislative prayer was traditional and acceptable on that basis. But what makes Town of Greece versus Galloway interesting is not so much the conclusion that the prayer by the town council is acceptable, but it's the fact that they've altered the test for determining whether or not something violates the Establishment Clause and, by a certain extension, the Free Exercise Clause of the First Amendment. Now, putting that in perspective, the Constitution itself under the First Amendment does not use the term freedom of religion. Instead, there's two aspects that are brought into play, where it says Congress shall make no law, and then several different pieces. One is speech and press, but when it comes to religion, it says that Congress shall make no law respecting an establishment of religion, nor inhibiting the free exercise thereof. And as a result, government action can violate a person's constitutional rights or a group's constitutional rights in one of two ways, either by being an establishment of religion or a violation of a person's free exercise rights. So it's very different from the idea of just a generalized freedom of religion. As a result, we have tests to determine whether or not something violates those rights. And it's been a little bit in flux since about 1990, but the basic core test has always been the Lemon versus Kurtzman test from the early 1970s, and it's a three-pronged test that if a statute or an action violates any one of the three prongs, it's unconstitutional. The first one was the action involved an excessive entanglement with religion. The second prong was whether or not the statute or action in question advanced or inhibited religion. And the third prong was whether or not the statute or action had a secular purpose. Now, what makes Town of Greece versus Galloway interesting is it shifted the test to whether or not the action involved has a coercive effect. Now, what makes it interesting for people like myself, or for that matter, has strong implications on either side, is that the coercive effect has an impact not only on establishment, which is where the Lemon test predominantly is applied, but also has a very heavy impact on the free exercise aspect of religion. And that change can be troubling, primarily because one of the things that judges try to do, not always successfully, is to create tests or modes of analysis that are as objective as possible. And even though we may quibble at times about what is excessive in terms of entanglement, what is a secular purpose versus a non-secular purpose, and so forth, or how much advances and how much inhibits religion, at least there's a legitimate standard in place. The term coercive, or the idea of a coercive effect or coercive action, can be highly subjective. It's kind of like in the area of sexual harassment law, where the law has moved steadily to not so much what the average individual would look at as harassment or harassing behavior, but more what was the state of mind of the individual that was experiencing it. Well, in this regard, coercive effect or coercive test has the opposite impact, where it creates a more subjective test. If I'm a judge and I'm asked, okay, is this too coercive, my lights may very well be very different from almost anybody else's, depending upon my particular view of religion in general, my particular view of the religious activity in question. Whereas when you're talking about things that are more tangible, like entanglements, purpose, and inhibition or advancement, it adds a lot more objectivity to the question mark. And so Town versus Galloway is going to be one of those cases that has a very interesting dynamic on the future of free exercise and Establishment Clause cases. It's too difficult to tell early on what kind of effect we're going to have. but it is something that could be very troubling in the future if we want a more objective judiciary.
Yeah, that makes sense. Does anyone else have a comment on this that they want to share?
To be perfectly honest, I don't know that much about the case, other than
Yep.
what the headlines have been saying in the first few paragraphs of each article. I just wanted to, come here and, get your input and see what you thought about it. Basically, what you're deeply concerned about.
Okay.
Yeah, for me, I get sort of the in theory how there needs to be a sense that people are free to practice the religion they want to in private, and obviously in some cases in public. My issue comes in is my problem with that is at times when if someone doesn't believe in an establishment religion or is an atheist and they go to a public meeting and that public meeting starts with a prayer, for me that feels like that person can have a sense that he's going to be disenfranchised because of his beliefs as he watches the crowd bow their head and pray to Jesus or Allah or whatever religion you may believe in at that time. So I do think public officials, politicians, and in particular, need to be careful when they exercise their religious beliefs at a public meeting. And I think that sort of that was my issue with the case. That it felt like it was a public meeting where they were having a conversation for the community, and people were concerned that it started out with a prayer or the right to pray.
Okay, when they start out with a prayer, was it just a prayer? Was the prayer group just the committee members, or were they engaging all of the, spectators, the citizens of the municipality or wherever? Were they engaged in it as well?
I'm not sure, Greg. Was it just the committee? I thought it was the committee. I thought it was the actual committee that prayed.
What happened was that the town council invited any interested clergyman, individual, or whatever to come in and open the meeting with a prayer. It was at the very start of any town council meeting, not later on in the meeting, but at the very start. There would be members of the public there, and the way it happened was the town council asked one of the secretaries or aides just to put out the word we'd like ministers or whatever, anyone that's interested to come in and open our session with a prayer. And from what I understand, particularly from Justice Alito's concurring opinion, is that what happened was they just got out the phone book and would call different churches and ask, are you interested in offering a prayer? Well, what happened was that almost every single prayer was of a Christian denomination.
Gotcha.
Now, when you have people that may very well be in the meeting that are Jewish or Baha'i or Muslim, or in this country, even now we have a significant Hindu population in some areas and so forth, that can be problematic because the prayers in themselves were mentioning very specific Christian elements like Jesus Christ rather than more generalized invocation of God to assist or bring a sense of peace or contemplation to the committee hearings and all of that. And the fact that they didn't, even in nearby towns where they could have found other ministers of other faiths and so forth to come in, it was a bit troubling. And a member of the community who was not a Christian brought a lawsuit saying, look, if you're going to open with a prayer, that's fine, but at least try and make it open up so it's not denominational, and put in some other faiths and so forth. So we don't feel like we come in for this meeting, we're part of the community, then all of a sudden we're kind of the odd men out.
Yeah.
Now, one of the things that came up in the oral argument, which was very interesting, was the timing of the prayer. because the town council meetings would have just a general session of at the very start of just general town business. Nothing really involving the public per se. It's more kind of administrative aspects and things of that nature, which the public was more than welcome to attend. And then partway into the overall town council meeting, it would turn into decisions involving particular citizens, like variance issues and so forth. And so one of the big questions was, okay, legislative prayer, Marsh decided that, we're okay with that, primarily because it is more for the legislators' benefit than anything else. But when you add what's called a quasi-judicial aspect to it, where a person coming in that is not of the Christian faith, for example, they have an issue that is determinative by the town council, like a variance or an easement on their property, putting in street lights or road signs or whatever in a rural area.
Gotcha.
And then all of a sudden, they're not Christian at all, and yet these Christian prayers are being said, invoking a very particular Christian deity. And then all of a sudden, okay, do you even care about us at all at that point?
Yeah.
Because religion can have a very motivating factor depending upon the issue or individuals involved. And people being people, they have a tendency to congregate more towards their own belief centers and people of similar ideals. And when it came down to the idea that it was at the very beginning where people weren't really needed there, it was just more administrative, but people were welcome, I said, okay, then the prayer deals more with the town council members themselves, not necessarily the public at large that's there.
Okay.
Yeah.
So that took care of that aspect. But a troubling matter remained the nature of the prayers themselves, because the members of the public are there. They don't want to feel left out. They don't want to feel marginalized and so forth. And so a rather interesting set of question and answers came about, particularly with Justice Scalia, when he was going on and on saying, give me an example of a totally non-sectarian prayer that everybody could agree with. And none of the attorneys could ever do it. I mean, it's one of those things that's very hard to do, even if you get it halfway right. So it was a real... I was shocked they even took the case to begin with. Even though I think they got it right by reversing the Second Circuit and saying this is acceptable, constitutional. I felt that it was one of those cases that you're bound to kind of muddy the waters on Establishment Clause and Free Exercise Clause issues. And the majority opinion did something, one, that I wasn't expecting, but two, troubles me, because they changed the focus of the test, and it becomes much more subjective. I mean, what may feel coercive to you may not feel very coercive to me if you and I were judges on a particular issue. And the town council, I mean, all sides acknowledge the town council wasn't trying to marginalize anybody or keep anybody out or anything of that nature. And Justice Alito even said this case is more about just poor secretarial work going through the phone book and not kind of expanding a little bit.
Gotcha.
If it had been deliberate, it would have been a totally different case, even for Justice Alito. So it's a case that was kind of odd that they took it, because it was, both sides even agreed we don't have a problem with the prayer in general. It's more we have a problem with the way they did it.
Yeah.
And but then they end up getting an opinion that, well, I think they got the conclusion right that the Second Circuit was wrong. The prayer is acceptable in my mind, and just like the court said, but they changed the test. And I don't like where I see that as a possibility for the future.
It seemed like, though, they were saying, from what you mentioned, that they were looking at it from a religion versus religion standpoint, saying, well, give a sort of a prayer that all religions can agree to, and I
Mhm.
get that. But what if someone was an atheist in that, right? So there's no prayer that that person would agree to that made sense to them.
Mhm.
So doesn't that open them up to someone saying, well, I, as an atheist who don't believe in anything,
Yeah.
religious wise, I was offended
Mhm.
by this. And I think my rights could have been
Mhm.
violated because I don't
Yeah.
believe in a religion. How would they tackle that where they didn't, when they don't have to come up with a, well, you all can agree on one prayer and you all believe in prayer,
Yeah.
but this person
Here's
doesn't.
here's where people can have trouble with the court actually taking the case and deciding the merits on it, because this wasn't about an atheist coming forth. It
Yeah.
isn't like the Newdow case from California over the Pledge of Allegiance about 10
Yes.
years ago, where you had a person that was genuinely an atheist and was trying to get third-party uh, litigation status on behalf of his daughter, who he did not have custody of, to argue the case the Pledge of Allegiance in school is unconstitutional, particularly in light of the words "under God" within the pledge itself.
Yes.
And the court said you don't have standing, so they left it pretty much out in limbo. But it's this case here is where everyone was saying, "Look, we don't have a problem with prayer. We just have a problem with how this was actually done by the town." And so it's another case of where the court, I think, and a lot of people have mentioned it off and on, why'd they take this one? If you're going to take a prayer case, take one that deals with an atheist challenging it, or
Yeah.
at least has some atheists as part of a group of people, both religious and atheists, that have problems with it. So you can really address the question, because it leaves
Yeah.
a lot of things open for discussion.
And that's what I mean. So it sounds like this case will come up again because, like you said, they were saying, well, they weren't broad enough for going through the phone book to find more people to talk
Yeah,
about their particular
yeah.
religion. So grow the sort of base of religions that you can pray at
Mm-hmm.
the meeting. But if you
Yeah,
don't want no one to pray at all, that's a whole different case, a
yes.
different circumstance.
Very different case.
So
Very
I was, so you're right. The fact they took the case only to probably take a similar case again in the future
Yeah.
is
And
interesting.
the fact that they changed the test in its entirety from one of entanglement to coercive effect, that opens the door for a significant amount of litigation in the future, because it brings up entire realms of Establishment Clause issues, whether it be tax issues or it involves school issues like textbooks again, or transportation or use of school facilities. Um, uh, One of the things that uh, was going to be in there that never really reared its head heavily was the Religious Freedom Restoration Act. I was kind of surprised. They made some mention of it, but not. It didn't really go heavily into that.
Can you explain
And
that?
well, in 1990, the Supreme Court issued a decision that said that facially neutral and neutrally applied laws that have an impact on a person's free exercise of religion were acceptable under the First Amendment. And the case happened to deal with the use of peyote in Oregon, where I'm at. And it was Smith versus Employment Division, or Employment Division versus Smith, one of the two variations. And Scalia wrote the opinion, and what it dealt with was two drug counselors were Native Americans, and they would use ritual peyote at very specific Native American rituals with their tribe. And they failed a drug test. They openly admitted, hey, we use peyote as part of a religious ceremony. It's part of our religious liberties. Well, when the court said that Oregon was justified in firing them, uh, it caused a big uproar because it made a significant shift from the Lemon v. Kurtzman set of tests. And the Religious Freedom Restoration Act uh, changed was worked out so that it would basically reverse that decision. And essentially, what it did was not necessarily mandate the lemon test, but it essentially was saying that courts need to be looking at a person's free exercise rights more than facially neutral laws, just because we may not like a particular policy or whatever. And and they were doing that. That and RLUPIA had to do with a lot of neutral laws that needed to be broader so that people of faith could have equal access to government buildings, schools, things like that, as far as access to facilities, like for public meetings and things like that, but also you can practice your religion and not fear that you might get fired, for example, like Native Americans using peyote, and things like that. And it's been an interesting number, about 20 years now, where it's used in a particular way, but now it's starting to be brought up in a lot more aggressive way about individual cases that in the past, like, what are you doing? This isn't more broadly used. It's not going against a particular statute and things like that. And it didn't get really brought up, which was surprising. It's called RFRA is RFRA, and then RLUPA is the other one. And they're just not being brought up in this case, and yet people thought, oh, this will be a no-brainer. Marsh, legislative prayer, it's okay. But then also Religious Freedom Restoration Act, more religion in the public square. But it was kind of not really touched on too much. And then you have this change in test. You know, okay, where's the court really going? They've opened themselves up to huge amounts of litigation under the coercive effect test. And what might be interesting is, okay, is establishment, which is rather formalistic and rather hands-on, going to, which pretty much necessitated a test of something like entanglement. Are you getting too heavily involved and too much of the elements of that? Now it's more, okay, how do people feel about a particular activity?
Yes.
And it's like,
that's
wow,
subjective.
Very subjective. And it's really difficult to write any bright line boundaries or standards behind a test like that. And it'll be interesting to see what happens. And so this is one of those odd cases where I can say I agree with the conclusion, but I am very wary of what the court did as far as the reasoning behind it. Yeah, it'll be very interesting.
So Robert, listening to that, what's your thoughts on, do you expect there to be more lawsuits when it comes to more public prayer and public events? Or,
well, like you said before, it was entanglement. You know, you get the government out of it, stay out of religion, it's fine. But what sounds like what they're doing now is letting them go into a certain degree, put their toes in the water, so to speak, and and see how much they can prod you before you react. Sounds to me like we're gonna have a whole town councils in there, like starting prayers. They'll have a non-denominational 1 week, then the next week they're having evangelicals come out and try to convert the entire the public. Talk about tax liens and everything.
Yeah, and that's the coercion, right? You were talking about coercion.
Yeah.
Standard before.
Yeah, it's like when the court says this is okay, even though in a number of prayers, like the particular Christian view of Christ being Son of God and so forth, is specifically mentioned or specifically referenced. If that's not so bad, then what would be coercive? If you're having one particular theological point of view, the Christian point of view, and that's okay, and it's not coercive, even though you may have members of other faiths in the same audience and so forth, what would be coercive? I mean, and that's another troubling aspect when you get into a highly subjective test.
Yeah,
I mean, I've always been a very strong proponent of government staying out of religion,
I agree.
mainly because
Yeah.
it's like, what's government so afraid of? That individuals won't have a faith? Well, that's their right. If you have the idea of free exercise, then you also have the right not to exercise a faith or a particular aspect of faith, whether it's prayer or going to church or synagogue or mosque or whatever. And if you have free exercise and you also have the establishment clause where government may not establish religion, that to me says government should be as much as possible hands off. I mean, I can see where government creating tax exempt status for churches, whether it's Islam or where it's everybody gets a tax exempt on particular on churches and whatever. That makes sense because that way government isn't having any involvement, saying, hey, look, we're not involved with your money, we're not involved with your property or anything like that. You're tax exempt, so we're not even touching you. So that makes sense to me. But when you get into people's practices, whether it's prayer or a church attendance, or even like, say, the old Sunday blue laws and all that stuff, to me it's like, government needs to really stand back if you want to have a realistic explanation of what the two prongs of the First Amendment actually mean. When the court struck down school prayer in the early 1960s, I think President Kennedy had it exactly right. He said, we may not like the fact that school prayer isn't in the schools anymore and all that, but we still have one very important option, and the students have one very important option: pray ourselves.
Yeah.
And ever since then, when students or whatever want to say a prayer and it's been stopped for any reason, the courts have said, no, 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 you can't do that. They can do that on their own. So, to me, government, if they want a good understanding of what the First Amendment means, it means hands off.
Yeah, it means you don't stay out of it.
Yeah, it means you don't make a negative comment about it, but you also don't say, hey, this is what's going to happen, A, B, C, and D. I wrote an article once where I talked about judicial review, and that's where the court decides whether something's constitutional or not. And I said, the people that defend school prayer and things like that are usually, and the majority of our country is Christian, but it's usually the more conservative Christians that do that. And that's fine. That's their point of view. They have a right to have that point of view. But here's the thing. If they get that answer, school prayer is fully constitutional and so forth, what if in a community that, however it happened, is predominantly Muslim, for example, and Muslims pray at certain times of the day,
Yeah, 5 times.
5 times a day, and they said, okay, well, we want prayer in the school, in the public schools, so there will be prayer these 5 times during the day. And I can't imagine that the more conservative Christians in that community wouldn't be up in arms saying, oh, that's not of our faith, that's a violation of our constitutional rights under the establishment. You're establishing a religion, the Islamic faith or whatever, and they'd be in court screaming about it in a heartbeat. And my response would be hey, you're doing the same thing because you want your prayer. So what's the difference here?
See, and that's a tough thing even about the council meeting. So as they're looking through the phone book, what are you going to do at the next council meeting? You're going to have 10 different religions offer a prayer in the beginning?
Well, what happened was, and this is what a lot of communities will do, is they put out the word in the newspaper, the radio, and so forth, and say, look, anybody that wants to offer a prayer, doesn't matter what your religion is,
gotcha,
whether it's Baha'i or Islam or whatever, you are welcome to contact the council and set up a date where you will offer the prayer.
Now,
And a
one
lot of
person
communities do
offers
that.
the prayer. Is that sort of the what?
One person offers the prayer. Now, if you have a community that has over, say, a year, you have 30 Christian prayers, 20 Jewish prayers, a few Muslim prayers, or a Muslim cleric offering a prayer, or a few Baha'i prayers, and that. Most communities would say, okay, we're meeting our obligation. We're opening it to anybody. And if
Yeah.
an atheist wants to go in there and appeal to,
Say a
say,
few words.
nature, or say nature, for
Yeah.
example, or invoke peace and harmony, or things like that. If the communities are doing that, then most people, myself included, will say, hey, there's absolutely no problem, because they are opening it up to everybody. They're not making a decision about who gets to do what. But as it stood, whether it was a clerical error or just poor secretarial work or whatever, it became an issue with this one. I think the figures, I have the opinion here, but it's too hard to find it. It was in Justice Kagan's dissent. Was like out after the suit was brought up and all that stuff, they started changing it. Out of 108, I think it was, prayers, 4 were of non-Christian origin. And so it was like, well, what did you do? Did you just contact 4 people that were not of the Christian faith and bring them in? Or what? I mean, how do you do this? To me, just the idea that courts are getting involved, particularly with this new test, and can say, well, let's take a look at how the government did this. What were they doing with respect to religion? What were they doing with finding people of prayer and so forth, people to pray and things like that? To me, you're starting down a big road where government is very much involved in religion itself.
Yeah, and that is interesting because the council meeting is held by government officials, by the local government. So in a way, they're saying the local government has a right to then search out a person or persons to offer a prayer before an official public government sanctioned meeting.
Now, the big thing is, and here's where the history gets interesting. Okay, in 1984, I think it was 83 or 84, in Marsh v. Nebraska, the court upheld the idea of legislative prayer, opening state legislative sessions, and that encompassed also the federal legislature as well.
Yeah.
The history of it is very interesting because in 1774, with the First Continental Congress, just before the Revolutionary War, they opened it with prayer. That's historically documented. The first Congress in 1789, under our present Constitution, they opened with a prayer. They also hired a chaplain for the House and a chaplain for the Senate. And so that was already well in place when the First Amendment was adopted. And so you can have a logical argument that when it comes to legislative prayer, that the people that wrote the First Amendment perfectly well understood that the idea of legislative prayer was okay. Because if they have a chaplain in the Senate, chaplain in the House, they open each session with a prayer, then why on earth would they write an amendment that would effectively negate that, as far as the idea behind it? And so what the court did was say, well, in terms of legislative prayer, that prayer is focused at the legislators.
Yeah.
And so it's not about the public or anything like that.
Okay, and this one crossed the line because the public was at the meeting.
Well, the public had the potential of being involved in the meeting. And that's why Justice Alito and others were saying, when was this prayer done? Was it done during just kind of the administrative aspect of the meeting at the very start, where nobody from the public was required for anything? Or was it during the more quasi-judicial section where certain people had to be there if they had a complaint or an issue that needed to be decided by the town council, like a variance or easement issue, or road sign or light issue or whatever. And so I think historically there's a great argument for legislative prayer itself. But when we get into the nuts and bolts of practices, I think we have to have a more rigorous examination and test. And I think this whole coercive test aspect loosens it up way too much. It becomes too subjective for any judge, really. I don't care if you're Catholic, you're Mormon, or you're Jewish, or Muslim, or Hindu, or whatever. If it's something that doesn't offend your particular religious sensibilities, you're going to ask them, well, how can this really be coercive? It's just natural, type of thing.
Yeah.
And that concerns me, because even Justice Scalia himself has said, and Justice Breyer and all the others have said, hey, if you can't put your personal views aside and make a decision that basically makes you pretty well sick, even though that's what the law dictates, you're pretty much in the wrong job. Well, if you're creating a test that essentially allows you to do to keep you in your perfect little comfort zone, that is pretty much allowing the judges a lot more free rein than they should have. I mean,
Okay.
and it is troublesome. It really is. I like how Justice Scalia said it once about judges needing to be able to make decisions that they really don't like, and he did it. The big one that he brings up is flag burning, and he was the fifth vote to uphold the constitutional right under the free speech clause of the Constitution to be able to burn the flag in 1989 and 1990, both at the state level and federal level. And he said, hey, if it was up to me by myself and I was king, people that burn the flag, they'd be in jail, period. But we have a constitution, and this is it. And so I had to do it, even though I don't like it. And the coercive test on religion, when it comes to like establishment clause issues, it loosens it up too much to be able to get away from that idea that you have to be able to do what you really don't like.
Got disconnected there for a second.
Hey.
Am I still there?
Yeah, you're still there. I see your cat.
Yeah, I see my cat too for some reason. I don't know what happened. It just lost network connectivity, it said, and
No, that's fine.
But going off on a bit of a tangent here. A little while ago, Greg, you said you didn't have a problem with them like putting an ad in a paper saying whoever wants to lead a prayer in whatever religion they want can just come up and do it, which
Yes.
I agree with in principle, but we all know in reality what happens.
Mm-hmm.
There's an evangelical board member who is not going to put up with that.
Yeah. What I was talking about more was you leave the board out of it in terms of them deciding who gets to do what. This would be a way for it to be as neutral as possible, where you say, okay, we're not going to decide who does the prayer. We're not going to decide what the prayer holds. We're just going to offer it to any person of religious faith or whatever that would like to open our meetings with a prayer. So that way they're not making the denominational decision. And you're never going to have a perfect setup, unfortunately. This is just one way to keep it as neutral as possible and not entangle government too much.
Yeah, but town councils are pretty much autonomous and they do what they want.
Yeah, it's troubling. And like I was mentioning before, one of the big questions was at what point in the town council meeting was the prayer even offered? And when it was just purely administrative or legislative in effect, then the prayer they looked at it under the Marsh decision. If it had been later where it was a quasi-judicial element, where people in the public needed to be there because their issue was being brought up or whatever, then even Justice Alito, one of the most conservative on the court, said that would be very troubling and it would cause some serious problems.
Yeah.
It's a tough question no matter how you answer it. And historically, there's a good argument, like I mentioned before, that it really doesn't, the legislative prayer does not violate the First Amendment, but at the same time, the way the court answered this question in the majority opinion is very troubling on religious liberty issues in the future.
Yeah, because you said it was subjective, right?
Very subjective. When you go from something that is relatively neutral, like is there an excessive entanglement, which is fairly tangible, to something to test as the coercive effect, which is very intangible and very subjective on the part of any judge or jury for that matter, it raises some very serious questions when it comes to protecting the constitutional liberty. And I'll be honest, I have some problems with it.
I definitely have problems with that. I mean,
yeah,
we've got people in power who don't think, waterboarding is torture.
Yeah.
I can't imagine what they think coercion is.
Oh, I know. In terms of waterboarding, I was floored when this happened. John McCain, who, if anybody knows what torture is, he does. After his experience in Vietnam as a POW for over 7 years, he came out and said flat out, "Waterboard's torture. Period. It is. No, hands down, it's torture." And a lawyer, I think it was John Yoo, but don't quote me on that. I think it was. I may be wrong. Right. But he came out and said that obviously John McCain doesn't know the full nuances or something to that effect about enhanced interrogation techniques. And my response was, what? Somebody that's literally been tortured? He would know better than an attorney what torture really is.
Yeah. That is so true.
And so coercion, it's in the eye of the beholder too much.
It is, and like we stated earlier about obviously if this was an atheist bringing a case, it brings a whole different dynamic to it.
Yes.
But also, even if the community, the council called every person in the phone book, but they lived in a Christian community, the odds are that's what you're going to end up with. So you're going to continually have meetings like that.
And that's where the newspaper ad can even help with that and keep it even a little bit more neutral, in that if you open it up to any member of the public that wants to give a prayer.
Or maybe not even a prayer at all. Why does it have to be a prayer? Couldn't it just be a, I don't know what you would call it. Some sort of salutations in the beginning of it.
Yeah.
It just seems like there's an obsession with having a prayer at the beginning versus nice words about the community at large and everything.
Yeah, and it opens up a lot of possibilities there for permutations on later cases. I don't know what's going to happen. I mean, one of the big question marks, I mean, people are constantly looking at the courts saying, are they political or not political? Are they religious or not religious? And there are a lot of people that have been tried to be as neutral as possible. I mean, my favorite example is William Brennan, probably one of the most liberal members of the court in its history, and he desperately did not want to get assigned the opinion in Roe v. Wade in the early 1970s. Even though he voted in favor of what happened in Roe v. Wade on abortion, he could only imagine what the Archbishop, and he's a Catholic, what the Archbishop would have to say to him privately afterwards. And he just did not want to do it, but he voted in favor of it, but he didn't want to write the opinion. And but you have someone like Scalia, who is very strident on a lot of different constitutional issues, and he has very good textual analyses on the Constitution. But when it comes to a couple of issues, particularly when it comes to religion, I don't want to just flat out say he's insincere in terms of his objectivity, but it raises some real questions because he's a lot looser in the interpretation, in the interpretive mode, than he is with almost anything else. And so it raises some real questions about his objectivity when it comes to religion. But then again, I could be wildly off base on that.
It's possible. All right, this was good though. I know it's getting late. It's like 12:15. But this was a really good conversation, and I apologize. Obviously, I wasn't at fault of this one, but that things got to a late start because of the internets. As one congressman, or was he a senator, said, it's just a system of tubes. Apparently, one of the tubes were clogged up. But I hope everyone enjoyed it. I know 2 people signed on and signed off, but we'll do this again next week. We try to do this on Wednesdays, but things got in the way. We had to do it on a Friday. So hopefully next week we can do this again, and I hope Robert can come back and join the next conversation. We'll sort of take a vote. Maybe we'll do it on Google Plus of what topic we want to discuss next week, and we can get more people to join in.
Okay, great.
Sounds good. I appreciate you, Greg. You scared me more than I was before now. So.
Then I did my job well.
Cool. Well, you guys have a great weekend and a great night, and let's do this again next week.
All right. Thanks, Damon. You too.
All right.
Bye, Robert.
Thanks, guys.
I appreciate it. Good night.
Good night.
Good night.